Good morning everyone and welcome to this month's webinar where we're going to be looking at how you can manage an effective redundancy programme and how we can prepare for change. And so as with any business project, careful and thorough planning is vital, and in the case of preparing for redundancies this is particularly true, as you need to ensure that your approach to handling the process leads to a fair and legally compliant dismissal, should that be the outcome of the redundancy process. So today I'm going to be taking you through what you need to consider when at the planning stage and what must be included in your preparations and planning. And as usual, a copy of the slides will be shared with everyone within the next few days after the event. So before we get going, we just would like to introduce ourselves as we normally do. So if you've not joined us before, I'm Victoria Templeton, one of the HR Knowledge Managers here at HR Solutions, and I'm joined again this month by my colleague Abby Ashford. Abby is our lead HR consultant who's responsible for our consultancy team here at HR Solutions, and Abby will be supporting in the polls and questions and answers at the end. We are also supported by Drew. He shall be on hand in the background to help deal with any technical issues. So hopefully we won't encounter any, but we've got Drew on standby to help us. And because we've got lots of you who have joined today, we've put you all on mute, but obviously we do want to hear your questions as usual. So when we see this slide, then that's the point we're at the end of the webinar and we're ready to take your live questions. So here's a quick run through of how you can submit your questions. So on the screen now, what you'll see is an image of what your GoToWebinar panel would look like. So just please type in your questions in the questions pane. As I said, we'll aim to read out and answer as many as we can at the end. If we can't get through them all, then we'll hopefully be able to follow up with everyone afterwards with some written responses. So before we look at what you need to consider at the planning stage of a redundancy programme, I'm just going to set the context behind why we plan. But the majority of the webinar will be exploring all the elements that's going to be going into a project plan for carrying out redundancies. And as I said, our aim is to ensure a fair and legally compliant redundancy process. Abby and I shall then take your questions at the end, so please do submit these as we go through. So let's start by considering why we should plan for our redundancies. And I'm going to just run a few quick polls just to help with the context. So I'm just about to launch the first poll, which you shall see coming up on your screen. So if you just bear with me for the moment. Now these polls are confidential, so they're anonymous, and it's just really to gauge where we all are in regards to redundancies. So is your business considering making redundancies in the next 3 months? Now just to let you know that if you're wanting to participate, then just make sure you're not in the full screen mode when you're running answering the poll. So yes or no, or the other answer is yes, but after 3 months. So let's have a look, see where people are at. So we'll just wait a few more moments, get a few more votes in. Okay, let's close that. And I'm going to share the results with everybody. And hopefully you can see on the screen the results. So we have 28% of you are actually planning, considering making redundancies in the next 3 months, and that doesn't come as a surprise at all, given the economic climate that we're operating in at the moment. 40% of you are saying no, and 32% of you are considering it, but not immediately within the next 3 months. But I suspect with, as I say, the economic climate and the challenges that employers are facing, them that doesn't come as a surprise either. I don't know if you've got anything you want to contribute, Abby, from your experiences in from a consultancy side, if you're seeing more redundancies happening or planning for.
Yeah, we are at the moment, sadly, and to be honest with you, I mean, we do deal with the SME market, and lots of our clients are doing redundancies, even if they are just 1 or 2. So yes, I would say it's very prevalent at the moment, and people are either planning to do them this side of Christmas, or to see how we get through these difficult last 3 months of the year and planning it for January time. Yeah.
Okay, thank you. So I'm going to run a second poll, and it's more about the numbers now. So how many redundancies are you anticipating in your organisation? So we have 3 categories of fewer than 20, between 20 and 99, or 100 or more. And I'm sure you'll guess why we've got those categories. Obviously, they're the parameters in which we consult. So let's wait for a few more votes, and then we'll see what the results are. Okay, can I close that and share the results with everybody? So we have 88% of you that are anticipating fewer than 20 redundancies, and 12% 20 or more, but no more than 99. So that's interesting, and that'll help us. Obviously, we'll come on to talking about consultation and obligations throughout the session. So that's good to know. And then I do have a further poll. And this is whether you are unionised. Okay, let's see any more votes, and then we'll close it. Okay, so let's share that. So 30% of you are unionised, and 30% of you are unionised, and 70% of you aren't. And that's probably not too surprising. And I suspect we may see more over the coming year, perhaps. I know we're getting queries about unions approaching organisations about recognition, but there's so much going on, isn't there? External factors that affect business and employees' employment. So who knows how that will unfold? But okay, so 70% of you aren't, and 30% are. And then just the final poll before we get going on to the next part, and that's more about how you feel in managing the process itself. Do you feel confident in carrying out a legally compliant redundancy process? Wait for a few more votes, and then we'll just close that. Okay, let's close and share that. 59% of you aren't, and 41% of you are. And I think with redundancies, and I'm sure Abby can agree, you know, it is probably one of the hardest business processes activities to undertake, because ultimately you're dealing with somebody's continued employment and having to make decisions on that. So it doesn't come as a surprise, and also it can be a minefield, can't it, in regards to employment law and rights and obligations. So hopefully today's webinar will help provide a little bit more confidence to you. So let's get going and carry on with the slides. And the first sort of part we're going to look at is about why do we plan? Well, it's a topic which can leave many employers not knowing how to best approach. As I said, it has massive repercussions if any part of it is handled incorrectly. And we're going to look at those shortly. But having a plan is going to ensure that all your activities are identified, that you can put timescales to them, and it can provide a clear line of accountability and responsibility, which is essential for any successful delivery of any project. But by planning, it also means that it helps to ensure the process can run smoothly, and it also helps to ensure that you do carry out that fair and legally compliant process, because you're making sure that you've factored in all of your legal obligations into your planning. And we're going to be going through what your legal obligations are in this webinar today, that will help give you some ideas to what you need to be considering in planning for your redundancy programme. But also having a plan can actually give your line managers who are delivering on it that little bit of extra confidence. You know, it is a topic that can lead many into not really knowing how best to approach it, having very difficult conversations. But if you have a plan that's clearly laid out, then it's going to just give that extra piece of support to those who are required to deliver on it, because they're essentially being given the instruction of what happens at what point. So it's just that framework to help. And finally, a phrase that I was taught back when I was studying my CIPD, way back, but the phrase failing to prepare is preparing to fail is so accurate, and not just in regards to when we're looking at redundancies. So being prepared for carrying out something like a redundancy, you know, you are essentially dealing with someone's livelihood and deciding whether or not they're going to have a job at the end of the process. Preparing is going to help you massively going into that. Preparing and planning for it fully will also help minimise disruption to the business, and hopefully your employees can maintain that certain level of employee engagement, because if you're clear up front as to what the process is going to entail, it will hopefully help reassure people somewhat, although it goes without saying, naturally employee engagement does get impacted when there's massive announcements and change going on in the business. This illustration here is just to highlight the risks. So if there's not an adequate plan for how you manage your redundancy programme, so it's going to be obvious that when handling a dismissal, either you are susceptible to claims of unfair or unfair dismissal claims, or treating employees different during the process that can lead to claims of discrimination. You can also be faced with breach of contract claims too. So when you're preparing and planning for redundancies, you really need to ensure what the contractual terms that your employees are under, because, for example, if you're not given the right notice, that could be a breach of their contract, or it would be a breach of the contract. You've also got both the direct and indirect costs that can arise from a redundancy dismissal process that's potentially flawed. So, for instance, if we think about the direct costs, you know, they're going to be things like your financial awards, should you have to pay out when an employee successfully wins on the claims, such as your discrimination and fair dismissal claims. But there are additional costs too. So legal advice when defending the claim, you might have external third parties in helping you to prepare defending your case. And when it comes to the tribunal day itself, then whether you are represented by a solicitor or even a barrister. We then have indirect costs as well that can come about because of a failed redundancy process. So this will be things like, if we think about the tribunal, then time out of the business to attend the tribunal. You have to put the time in and the preparation in defending your case, which can take many months. And you'll most likely have several witnesses that you need to prepare and support in the lead up to it, and also their time out. That will be the managers that have been managing the process, and perhaps any HR that you may have been supporting, and even senior leadership from the business may also be in attendance as well. And a significant indirect cost to the business would be things like negative publicity. So if you are facing claims at tribunal, either individual or several claims, then clearly that's going to bring bad publicity to your organisation. And I guess what we need to also think about is the use of social media nowadays. Employers have to be mindful of how it presents itself, not just internally, but to its employees, but also how it can be impacted out in the community. So, you know, there's lots of implications for not adequately following a fair and legally compliant process. So now we're going to get on to talking about the bulk of, you know, what should your preparations entail? What do you need to be considering when you're about to approach a redundancy project? And I guess I've mapped out here the key areas that should form part of your redundancy planning and preparation. And I'm going to take you through each of these because they all equally have a key role to play for ultimately leading you to carrying out a fair, legally compliant dismissal. And so the first one is about the business case. It's fundamental for arguing a fair dismissal. So it is a key document, and it's for several reasons. So it can have a significant impact on how employees react to the announcement. Because if you're setting out the context and reasoning for the proposals, you use that then as a basis for all your communication. So you're not sharing the business case document with your employees, clearly, but the information that you're containing in there when you're setting it up front can then be used consistently through all your materials, through your announcement, through your letters and the correspondence, any FAQ documents you put together. So it just is a further example of how you can evidence that you carried out redundancy process for genuine reasons, and those reasons are consistently communicated throughout. It can therefore have a significant impact on how employees react to the announcement. So when you're pulling together your business case and your reasoning for why you're doing it, and then using that to communicate, you're more likely to get understanding, and perhaps whilst they might not like the message and what's going to be potentially happening, they're more likely to understand why you're doing what you're proposing to do, and therefore more likely to be accepting of the situation. It's also going to limit the likelihood of employees challenging the process, because your business case, as I say, will set out the reasoning behind the process, the proposal, and giving out that clear explanation into events and how the business proposes to move forward. And so it's giving that sound basis for your proposals. And having that well-written business case can actually support you at tribunal when defending claims, because it's that written record of what the business situation was at the time of the announcement. So it's going to be setting out the potential solutions to that situation and how it's able to achieve those. So it's really, really important to illustrate and support your defence in what you're proposing. So that's very much the first step when you're planning for redundancies, is setting out the business case for it. And then as part of this same process, it's about thinking about how you're going to approach the project. So like I've talked about, having that clear plan of action, and doing so will mean that you ensure you manage that redundancy process in a legally compliant way, and that you operate within the legal timeframes. During a redundancy programme, you can have several tasks running simultaneously. So having that clear plan set out as to what's happening, when, who's going to be accountable and responsible and involved in it, will help the effective delivery of that redundancy programme to ensure nothing gets missed. So planning is really, really important. It also ensures that people are accountable for their actions. By assigning tasks, duties, you're giving responsibility and making people accountable to what they're doing in that process. And so they're going to want to ensure that they fulfill their own obligations and responsibilities. And finally, by sitting down right at the outset and setting out your plan of action and what needs to happen when, will help you to avoid missing out key activities that are essential. And we're going to come on now talking about those activities that form a fair project plan. But before we do, another aspect to consider is the support. And sometimes employers can steamroll ahead with a process with specific thoughts around the process, what happens when, but actually we also need to be thinking about the employees themselves who are impacted by the proposed change, as well as those who will be potentially left in the business. You know, it's thinking about your workforce and considering that, and thinking about how you're going to support people as you move through that redundancy programme. So when drawing up your plans and the business case, do consider employee engagement. So, you know, acknowledging that making redundancies I guess is one of the most difficult business activities that face an employer and an employee. Like I've said at the outset, managers may feel uncomfortable or nervous in delivering the message and having responsibility for managing the process. And we also need to be obviously mindful about those employees who are not at risk but are left in the business. They're going to feel vulnerable and perhaps threatened about their own job security in general. And of course, those employees who are directly impacted will feel naturally a mix of emotions. This could be shock, denial, anger, even resentment. It could also exacerbate depression or bring on periods of low mood or depression for some individuals. But there may also be some relief for some people. You know, you never know people's personal circumstances. You know, the timing of making those redundancies might be coming at a good time for somebody. So it's just recognise that there's a massive mix of emotions that go on. And so considering how you support everyone is going to be vital to that effective redundancy programme. It's not just all about the process and getting to the end result. It's about how you support and take your employees through that process. So some of the things that you can do to help support employees, well, we have employee assistance programs. They're actually available not just to an employee, but for line managers as well. So clearly they're set up in the organisations generally to help employees. They offer counselling, typically either telephone, some will provide face-to-face counselling for a limited number of sessions, and it's a phone line of support if they need some advice and guidance. From a line manager's point of view, as I've said, that there could be some line managers that have never dealt with redundancies before. They may feel not very confident in having to manage it and feel nervous. And so that's an avenue of support for them too. And they shouldn't be forgotten in the whole process. If your organisation has mental health first aiders, wellbeing ambassadors, you know, remind your employees, not just those at risk, but everybody that remains after any proposed redundancies take effect, you know, that they're good sources of support and help. And of course, training. So if we think about the actual redundancy process, do you want to consider offering some coaching training for those line managers who are about to lead on that process, who are about to enter into consultation meetings with their employees? That's going to help reassure them, alleviate any worries, concerns, and just help boost their confidence in going into the process. And of course, employee representatives. I know most of you are, if you are going to be undertaking redundancies, it's going to be less than the 20, but still think about what training should be considered, you know, for those elected employee representatives. Obviously that comes in when you potentially making more than 20 redundant. So there's training opportunities as well, and that's all about the support program that you're helping. And just remember, it's about, you know, you want to keep dips in employee engagement to an absolute minimum if you can, but recognising there will be an impact to employee engagement, but how can you alleviate that somewhat? And training and support will help. And then employees that aren't at risk must be supported to maintain employee engagement and motivation as well. Don't forget those people that will ultimately potentially be left in the business. You know, they're going to be losing their colleagues who they will have worked with potentially for years. And so it's a massive change for everybody. So think about just company-wide support. Another thing to factor in for helping you to ensure a fair legal redundancy process is around your HR templates and your communications. So what I would say is consistency is essential when managing any change program. So through that communication, it's fundamental for mitigating against risk because it's your audit process. It's your evidence to show that you've carried out a fair process, that your reasoning has been consistent throughout. You've not wavered off away from why you're actually holding and carrying out redundancies. And it makes sure that you can provide that effective employee communication and therefore hopefully mitigates any dips in employee engagement. And so when we talk about HR templates, you know, think about your template letters for once you've made the announcement, so a follow-up, your letters to invite people to their consultation process, You may want an FAQ document to circulate because many people probably have similar questions, and so that's another good mechanism in which you can cascade information consistently, because what you don't want is for Chinese whispers and for mixed messaging to get around. You really want to keep control of what you're communicating as you're managing redundancies. So HR templates are vital, and I would say they need to be established and signed off right up front at the start before you go ahead and doing all your announcements. And that leads me on now to talking about the announcements. You've written your business case, you've got your arguments as to and justifications as to why you need to do what you're doing, the reasoning, and now it's about how you communicate to the employees. And I would say it must obviously take place once that careful planning has taken place. The aim is to ensure that everybody is informed at the same time and provided with the same information, because you don't want misinformation going out or people hearing at different intervals. But you do also have to bear in mind there could be employees not in work on the day of the announcement. So what would typically happen when you're planning right up front, you will have an idea as the date in which you're planning to announce. So once you know when you're going to be announcing, look at people's schedules. Do you have people booked on annual leave for that particular day? Clearly you can't anticipate the sickness absences that happen on that day, but you will be able to anticipate there will be some potential absences. You may have people on long-term sick that you know for sure they're not going to be back at that point in time. So you need to factor in the announcement that you make on site to the people who are present at work that day should also be cascaded and communicated to those who aren't in the office. So we would suggest about having individuals within your either if you've got in-house HR yourselves, or you bring in HR support or line managers that are part of the managing the redundancy program, to be delivering that message over the telephone and using that script to help them, because what you don't want is people hearing from Facebook, social media, or just word of mouth and things like that. You need to ensure as best as possible that people know the announcement generally at the same time. And I talked about using a script. That's really, really essential, because you know then that you're saying the same information to everybody. And that will form part of a defence if you are ever challenged at tribunal as to ensuring that you carried out a fair process and the announcement was essentially the same across the company. And so the content and tone of the announcement sets really the relationship for the employee and employer during that change programme. And so it's really important to get that tone right. I guess, as I said, have that script, make sure you're comfortable with it, and then it's about reading it and just communicating it. Now, for some people, they may be able to familiarise themselves with it so well that they can just fluently talk through that script. Some people may need that script as a prompt. So you've made the announcement, and the immediate next steps is around thinking about your consultation. So on here, we've got a table just to illustrate, because it will depend on the numbers that you're looking to make redundant. So, and these are legal timeframes that we're talking about, so you really need to incorporate this into your planning. So if we look at the individual consultation, that's where you have fewer than 20 proposed to be made redundant, and your legal obligation is to start in good time. What that means obviously will be specific to organisation. You know, we're very much aware of employment legislation that many things are never defined, and there's that element of judgment and interpretation. But what we know from case rulings is that you must start in good time for consultation with your employees. It must also be meaningful. And again, the legislation doesn't set out what meaningful means, but we do know from case law that when you're consulting from an individual perspective, then it's making sure that you've allowed the employee to contribute and put forward ideas to avoid redundancy, and that you've given due consideration to all of those ideas. it's about making sure that you allow sufficient time for employees to be able to contribute and have a say on their own personal circumstances before you close consultation and decide. And things like, have you given serious consideration to finding suitable alternative employment and finding ways in which you can avoid redundancy? So can, more flexible type of working help eliminate a redundancy situation, for example? So these are all factors that should be explored and considered when you're in consultation, because when you're consulting with people where there's less than 20 employees, you don't have a specific time frame in which to consult. It just has to be meaningful, and you've got to be able to evidence that your consultation period of X period of time was reasonable and fair and was sufficient for all of those things that I've just said to be carried out. When you have 20 or more employees affected, then you have legal obligations in response to collective consultation and with trade unions if you recognise one. So whilst it's known as collective consultation, it's also advised that you do still offer individual consultation, because it's about enabling employees to be able to put forward any concerns and speak to you on a one-to-one basis. There may be some things that are potentially will impact the employee that they don't want necessarily being brought up in the collective consultation forums, and so offering that one-to-one opportunity will help support them through the consultation process and get their concerns aired and responded to. Again, consultation must begin in good time, but depending on how many job roles you're proposing to be redundant will determine how long your consultation period is, whether it's 30 days or 45 days. So where you are looking to make between 20 and 99 employees redundant, then it's a 30-day consultation. 100 or more, it's 45 days. So just be mindful of these timeframes that you're legally obliged to adhere to and factor those in your planning. And finally, there's also a legal obligation to notify the Department of Business, Energy and Industrial Strategy. So that's where you submit your form, which you're notifying the date of anticipated redundancies, the numbers, the area and the business in which are to be affected. They need to be informed. So don't forget that and to factor that into your planning at the outset of your redundancy. So you've got the consultation framework running. You then need to consider about selection pools, and a selection pool is where you're having to select a number of individuals for redundancies. So you use it when you need to identify which employee is to be selected from a larger group. The group of employees that form that pool will be identified as carrying out similar work and activity. So you've got to be considerate of when you're working out who is within that pool. You need to look and understand the job role that's being carried out across the organisation, and where there's that similarity, they need to be brought into the pool. Having a selection pool is a key part of ensuring a fair redundancy process. I would say that perhaps one of the biggest challenges or complaints you hear at tribunal is that the selection pool, either people were selected when they shouldn't have been, or didn't include the right people that should have done. So it's really important to correctly identify the selection pool, and that, as I say, ensures employees are selected for redundancy in that fair way. But how do you select people? Well, this is where you need that selection criteria, and because you need a framework in which you determine who is ultimately selected for redundancy. So you've got to make sure that it's fair and reasonable, and ultimately it's going to be the business's decision as to the method that's used. And as I said a moment ago, selection is probably one of the biggest areas and most common areas in which gets challenged when there's complaints at tribunal. So it's really, really important that you handle this correctly and plan up front how you're going to approach it. The criteria you use for selection must be applied fairly and should not discriminate. So you've got to factor in, do you know of any employees that perhaps have disabilities? Do you have anybody that perhaps may hold another protected characteristic, sex, race, religion, etc., etc., because the criteria you apply must not indirectly discriminate against those. So if we think, for example, using sickness absence as one of the criterias, clearly that would raise alarm bells from a risk perspective, because you could have somebody that's got high absence but it's connected to a disability, and therefore if you were to use that in selecting them for redundancy, then clearly there's a risk from a disability discrimination claim. So you've got to make sure that the criteria you use is fair and doesn't discriminate. Use criteria that's going to be relevant to your business, is justifiable, and preferably, if you can, always make sure it's measurable and can be evidence-based. So you can use things like performance ratings, disciplinary record, timekeeping, professional qualifications. They're just some areas in which you can use when you're selecting. And as I said, just with caution, be mindful around how absence records are used, and we would generally steer away from those. If you were to proceed in using attendance records in there, then just make sure that any absences that could be associated to somebody's disability are absolutely removed and excluded. But there's obviously concerns with using somebody's absence record. And for those of you that are unionised, then try and seek that agreement around the criteria that you're going to use. And when you're going through selecting, we would really recommend that you have an impartial manager or HR almost moderate or sense check the selection assessment, because almost having that second pair of eyes, an outsider looking in, is an opportunity to ensure that there's been fairness in that selection approach and will help to prevent any challenge. So it's really, really a good suggestion is to just don't, you know, when you, as line managers making the selection methods, have that then assessed impartially by another manager, perhaps more senior, and as I said, HR, just to be sure that they're satisfied that fair assessment has been carried out. Another thing to factor in with your planning when you're dealing with redundancies is about alternative roles. So an employer's legal obligation is ultimately to avoid dismissal. Sadly, that can't always happen, and an employer must look to undertake a reasonable search for finding suitable alternative employment for those who have been selected for redundancy. So what we need to bear in mind is when you're looking at alternative roles, consider if it's potentially a suitable alternative or alternative. So for example, you know, when we're talking about suitable alternative, look at the level of pay, the kind of activities that the job does compared to what they're currently doing, excuse me, the level of responsibility they have, if they're budget holders, for example, you know, what would this potential role be for them as a comparison, or through that assessment, is a role that's available simply a role and it's not in comparison with the role that they're doing now. And that's really important because it helps you to understand, I guess, you know, the obligations for taking up alternative employment when avoiding dismissal. And then we obviously have the thought of trial periods. Now, the legal position on that is a trial period is offered when you have served notice of redundancy, not before. So people may automatically assume that they may be offered a role even partway through consultation, but consultation hasn't closed, and therefore redundancy hasn't been confirmed, and therefore notice hasn't been served. So in that situation, there's no legal requirement to offer a trial period. But what I would say, what happens probably in reality, in common practice, it would probably be they would be given a trial period. But it's just really to emphasise the point that trial periods must be offered when you've served notice, where somebody's been found to have suitable alternative employment, but there's no legal requirement before notice has been served, because essentially redundancy hasn't been confirmed, they haven't been dismissed. That's ultimately what the point is of that piece. And then plan for how you're going to manage reasonable time out of the workplace to support those redundant employees in finding new employment. Do you wish to provide outplacement support? How much time are you able to reasonably provide? It's only a legal requirement when the employee has a 2-year service and is under notice of redundancy. But again, in reality, what we find is most employers provide it to all redundant employees. And I guess the thinking behind that is, you know, obviously to claim an unfair dismissal, you need that 2-year qualifying service. So plan for how you're going to manage reasonable time out of the workplace to support those redundant employees in finding their new employment. And then also what you need to consider when you're preparing for redundancies is the fact that the dismissal, should it occur, is going to be on the grounds of redundancy, and therefore it's one of the 5 fair reasons to dismiss. But that's only going to be a fair dismissal if a fair and reasonable process has been carried out. And I touched this on this a moment ago. You can only confirm redundancy or somebody's being served notice of redundancy after consultation, because the whole purpose of consultation is you're trying to explore with the employee or unions how you can prevent the proposal going ahead, i.e. the redundancies going ahead. What other solutions are there? And so if you're confirming somebody is redundant during that, it basically is not meaningful consultation, because you're not allowing that 30 days or the 45 days to consider how you can avoid it. So only when consultation is closed must you then reach a decision on your proposals and next steps and whether you're going to be confirming a redundancy dismissal. Obviously, we would always advise in communicating that face-to-face, but there must be confirmation in writing because you are dealing with the dismissal. So that confirmation in writing is a dismissal letter, and it must contain certain legal minimum requirements. And with the letter, you're effectively serving written notice. So just make sure, in line with their contract, that you're providing the right level of notice. Some contracts may allow for payment in lieu to be served, in which case it's an employee's decision as to whether they need that employee to serve their notice, to work their notice, or whether to pay in lieu. Now, if you don't have a payment in lieu clause in your contract, if you were to then manage the exit in that way, then you're dealing with a breach of contract claim because you haven't got the legal right to pay in lieu of notice. So just check your contracts as well. That should be an important part of your planning when you're looking up front about how to manage your redundancy. And then in terms of appeals, then, sorry, moving on the slide. So that face-to-face and the confirmation in writing, make sure it includes the effective date of dismissal, how notice is to be managed, final payments, and I've put here the right of appeal and a question mark. And I've done that because I don't know how many of you are aware, but there is no legal statutory right to an appeal process when a redundancy dismissal is taking place. And but what we typically see in reality, most employers will offer one. So, but actually, you're not legally entitled to an appeal. So all I would say on this is when you're entering into a redundancy programme and you're at the planning stages, think about how you've managed redundancies previously, how you've managed the exit and the right to appeal, because obviously you're going to want to follow suit as to how you've managed appeals in the past. And obviously there's pros and cons with offering appeals. For me as a HR practitioner, I would say that offering an appeal gives the organisation another internal opportunity to look at any contentious issues, address those contentious issues, rather than it going straight to ACAS and tribunal. So it's giving the employer another opportunity to address it and deal with it. And in theory, it could present a new opportunity for the employer, in that it might present the option for offering a settlement agreement if there's lots of issues that you've identified through that appeal process, and you make that commercial decision that rather than risk going to tribunal, where perhaps it's unlikely we're going to win, or perhaps it's 50-50, or you just don't want the publicity of going to tribunal. Having that appeal mechanism, when there are contentious issues, it can present different opportunities or new opportunities for the employer. So I return to the business case, and that's really just to sort of circle back to the beginning where I talked about the importance of pulling together the business case. And so in your planning for a legal compliant redundancy, obviously I've talked through all the areas you need to factor in, but when you're setting out a business case, you need to present that to the CEO, the budget holder, in that you need to basically explain why you're doing what you're proposing to do. So it's about setting out the background, what the proposed changes are and your overall aim. What are the risks to the business if the proposed changes didn't go ahead? Use the business case to identify possible risks associated with the process and any dismissal. So anticipate risks. So you've identified there's a need to go ahead with the redundancy process. No process is going to be squeaky clean and perfect. There will always be an element of risk. So always factor those in. Map out how you're going to be selecting. So what will your selection pool be? Which roles does it include? And what would be the proposed selection criteria? Include how you're going to consider alternative roles, what alternative roles may be there in the organisational structure. Set out how you're approaching consultation. Is it going to be individual? Is it going to be collective? And if it's collective, how you're going to factor in the opportunities for offering individual meetings with people, and what supporting materials do you have that supports that redundancy? And that might be proposed new job titles and person specifications, proposed new org charts, a copy of the existing org chart. So lots of supporting material, because the business case, as I said right at the outset, is really fundamental to how you manage a redundancy, and ultimately is going to be key to when you are unfortunately may have to be in the position of defending a tribunal claim. So we're now going to go over to some Q&As. So, Abby, do we have any questions that have come up?
We do, yes. Yeah, thank you for your questions. We'll go through them now. The first one I've got here is, when offering alternative roles to employees, if they don't want them, can they still opt for redundancy instead? So the answer to that one is yes, and that is purely if it is an alternative role. So that's as opposed to suitable alternative employment. It's very important to get that clarification right. So suitable is where it's a role that they can transfer into very naturally, no training required, they can just hit the ground running, as opposed to alternative employment, where it is quite a different role, might be different pay and benefits, might be a demotion in fact, but it's something where they might also need training. So it's alternative employment, but it's not suitable. And in that circumstance of alternative employment, a 4-week trial will be in play, and either party can conclude if that trial hasn't worked out, and that person can still leave on redundancy grounds based on their contractual terms, not on the terms of the alternative role they've been doing. So yes, that absolutely can happen.
Mm.
Another question we had was
Yeah.
about, well, what if we're making less than 20 redundancies? And that's, relates back to one of the polls you did, Victoria.
Yeah.
I think we will have a lot of people with just a few redundancies to make, but still wanting to do them in the right way. And in terms of following a full process, yes, we would say still stick to the key parts of the redundancy process and prepping for it, like Victoria's gone through today. Just things to watch out for. You might want to reduce the process because it's only for like one person, for example, or you might only be making people redundant who don't have the 2 years service that brings you full employment rights and statutory redundancy pay. But that doesn't mean that you can sort of slack off, if you like, and take reduced measures. Certainly, if there's only one person involved, you've got to be careful it won't be viewed as a fudged redundancy. There are situations, and we certainly get these calls, where somebody wants to remove somebody from the business, perhaps more for a performance reason, and it isn't a genuine redundancy. You do need to be careful in those circumstances. You can get found out, and then that can lead potentially to trouble for you, especially if someone feels singled out and there's a protected characteristic in play. You might have potential for a discrimination claim there. So just be careful if you've got a very small redundancy amount of people in play, just to make sure that you're treating them still in the right way, the fair way, how you yourself would want to be treated. And whilst you won't be doing a huge announcement to a large group of staff, you can just make it more personal. You can take that person aside, explain to them the business case, and still do that business case and use the information in the business case in your announcement to that one person or two people, and use it in any letters as well. So you've got that consistent message throughout of why that redundancy is having to happen to just that small group of people.
Yeah. Yeah.
And we've got one more question to finish off. What is the best way to announce to an employee who is on long-term sick? And I think I would view that more broadly, actually, just to answer, and that's not just long-term sick, but perhaps those on types of family leave, like maternity leave or even career breaks. You should do all you can to get the details to those people who are away from the business for whatever reason. And if you're doing an announcement to staff on site, you might ask another manager to use that same script you've put together to call that employee at home whilst that announcement is going on, so everybody hears it at the same time. Now, that might not always work in practice, but certainly planning for that would be good. Or you might be an organisation that works totally remotely. And so if you were arranging a call to announce over Teams or Zoom to people that unfortunately a redundancy programme was going to be initiated, you would perhaps invite people who weren't at work, who were off poorly, who were on maternity leave, to dial into that call and hear the same message at the same time. So,
but on that, Abby, that's what I was going to say. It reminded me of, don't do it like P&O Ferries did.
No, please don't.
Absolutely. We did cover it on a webinar a few months ago, so if you want to have a look back. But don't manage it like P&O.
Yeah, definitely. So anyone not at work that are unable to attend any form of announcement in person or on a call or by video call, they should be written to afterwards by email or post, just to explain that that announcement has happened, that you tried to get in touch so that they could be a part of the announcement, but instead that they've had to write to them to explain the details, and that they'll be in touch with an invitation to consult. So at least that person is engaged. They know that they are being included, and also to look out for more emails or posts that might be coming through with some consultation paperwork.
I can see we've got another question. It's about, we have an employee who is just informed as she is pregnant and due to give birth the month after she would have been made redundant and left the business. Do we have to legally pay her maternity, or she's been here for 4 years? So it's probably quite a complex query when you're dealing with maternity, pregnancy and redundancy, in so much as I guess the safest option is first of all, you're still entitled to maternity pay up to a certain point, aren't you, in your employment? But you've got to consider, obviously I've only got limited information, but do you delay the redundancy from when it's taking effect? So from here, I can't determine if consultation's closed or whether consultation's still ongoing. Essentially, one option for employees, you can delay redundancy taking place, because if somebody's going on maternity leave, a lot can change within an organisation whilst somebody's off on maternity leave, i.e. new alternative employment could arise during that period of maternity leave, which is where the argument can come from as to why delaying the the redundancy may be reasonable. Because a lot can change. There might be a vacancy that comes back which prevents that dismissal. I don't know if you've got anything to add there, Abby.
Yeah, so you could have the circumstance where it's a redundancy because the business is closing down, in which case, yes, legally obliged to pay the maternity pay, because I can see the service there, and you would most likely pay it as a lump sum in that situation. Or if you couldn't afford to do that, if you could keep the payroll open, if that was a possibility, then you would continue to pay each week or month. But if it isn't that circumstance, then yes, as Victoria said, you would consider extending the consultation period, if it isn't closed, throughout the whole of the maternity pay period, so that they have a very long consultation period. And certainly they can raise if they don't want that to happen, but you might offer it as a fair and reasonable employer. And so then at the end of the consultation period, which is the end of the maternity period, that person can then say, right, this is the situation I'm now in. What roles are there for me to come back to? And you can then have that conversation at the end of the maternity period.
And the important thing to note is that there's one particular area of all the discrimination laws that apply for redundancies, and that's when it comes to pregnancy and maternity, in that preferential treatment is given to an employee who is on maternity leave when it comes to being offered a suitable alternative role. They get precedent in that role.
They do.
So just to add that. So it can be complicated. I think you need to seek out specific advice for each scenario, and it's about how you can be as fair and reasonable, ensure they get their rights as they are entitled to, like I've just said, and then working out how best to manage that moving forward. So thank you, Abby, for that. I think that's all the questions.
Yes.
Yep. Lovely. Okay. So just to wrap up the webinar, just to let you know that we offer HR knowledge base. So you'll find templates. So if you are managing redundancy, you'd find a redundancy policy on there, all the consultation letters, outcome letters, selection criteria template, business case template. Obviously, but it covers the whole employee life cycle, all the material that we have on our knowledge base. So if you're interested in signing up to our knowledge base, and there's a link there. And I just want to run a quick final poll, and this is about if you'd like to hear from us about any of our services moving forward. So it's just going to quickly come up on your screen, and whether you want to find out about our training services, HR, health and safety, the knowledge base and payroll, let us know. We can get in touch with you after the webinar. So I'll just keep that open for a few more seconds. Lovely, and I'll close that. And then just to let you know, we have training courses coming up that are HR management and development. They're going to be all online. They're generally half days. So we've got disciplinary, quality, appraisals, grievance, communication skills, leading a team. You know, they're all online training courses that we're currently running at the moment. So if you are interested, we've got a QR code there and a link there that you can click to access. We also have health and safety training courses. So this is setting out what we've got coming up right through until February. So again, there's a QR code and a link if you want to find out more about that training. That's in person, it's not going to be online. With health and safety, obviously there's more of a reason for doing things in practice in person, so they will be run safely in line with COVID measures. And then we've got some upcoming webinars. So next month, we're going to be focusing on working with trade unions. So looking about how you can manage relationships, how you deal with the trade unions. So that's going to be really relevant, I think, now, because I suspect we're going to see more and more people signing up to unions. I suspect we're going to get more unions approaching organisations about recognition. And obviously, for those of you that do already work with unions, then it may be a webinar that will help just reinforce, you know, all the things that you're doing at the moment with working with them. And in December, we're going to be looking at how we plan for the year ahead. Next year is going to be very interesting from an employment law point of view. You may have heard that there's been a new bill that's been published in Parliament that's going through the stages at the moment, and that's about repealing the EU legislation within the UK laws that we have. So to cut a long story short, when we left the European Union, it was agreed through the Withdrawal Act that we would retain EU employment rights within our UK legislation. We are now looking, as a result of this new bill, to repeal all that and be able to create, amend, update our UK laws moving forward. So it's going to be potentially a massive year for employment law. So we'll be looking at that in the webinar in December, and obviously we'll be talking about that throughout next year as well. So look out for webinars on that subject. If you've got any further questions, please don't hesitate to get in contact with us, which you can do through the number in the emails here and our website. It'd be great to hear from you if we can help you in any way. And then after the webinar, you should receive a short survey that just asks for your feedback. We would, as always, really appreciate it if you could complete the survey, because that just allows us to improve our service that we offer to you. And then finally, just to thank everybody for joining me today and taking the time out of, no doubt, a busy schedule that you all have. Thank you to Abby in supporting me in the polls and questions. It's been great having your input, and thank you to Drew. Hopefully we didn't see any technical problems, but I never knew if there were, so that's a very good sign. So thank you everybody, and hope to see you in next month's webinar. Take care.